Good afternoon, everyone. Let's get started. Thank you for joining us for today's webinar. I'm Hal Perloff. I'm a partner in Husch Blackwell's construction group. I focus my practice for the past 21 years on complex construction and government contracts matters, including matters relating to the Davis-Bacon Act. I appreciate you taking the time today with me to learn about the Davis-Bacon Act and some of the coverage and compliance pitfalls that can trigger issues and problems in terms of compliance with the Act. I'm going to spend a good piece of my time talking to you about what my view is of best practices to avoid some of the pitfalls and problems that I've seen other contractors run into in dealing with the DOL and in some cases dealing with the Justice Department on issues that arise under the Davis-Bacon Act and related regulations. Before we begin, I'd like to cover a few housekeeping items with you. At the bottom of your audience console are multiple application icons for you to use during the program today. If you would like to take a minute, I'm going to highlight a few of these key icons for you so you can understand what they do. If you have any questions during the webinar, please submit your questions via the question box. Time permitting, I'll try to answer your questions when I reach the end of my prepared materials. If I do not get to your questions, we will follow up one of two ways. We'll either submit a question and answer sheet if we have a sufficient number of questions, or I may just reach out to you via email and respond that way. We truly appreciate audience participation, and I encourage you to submit questions, and hopefully, again, we'll have an opportunity to get to some of those at the end. There is also an icon to assist you with your viewing preferences. You can expand your slide area by clicking on the Maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulties, please click on the yellow Help icon. It has a question mark and provides information regarding common technical issues that you may run into. A copy of today's slide deck and additional materials are available in the Resources List icon. It looks like a little green folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Missouri, and Tennessee continuing legal education credit. Nebraska and Texas are still pending. If I didn't list your state and you're interested in trying to receive CLE credits for today's program, let us know and we'll be happy to assist you in submitting our program for CLE approval in your jurisdiction. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. So that's all the housekeeping items. Let's get into it. So we're here to talk about the Davis-Bacon Act, and I want to give you just a quick little background on what this statute came from before we go into some of the compliance issues that folks run into. So the Davis-Bacon Act has its origins in the Depression. I think it was passed in 1931. And at least from some of the historical accounts that I've seen, sadly, it also has some of its foundation in racism. Congressman Robert Bacon, and from Long Island, and for those of you who are guessing, you would be correct if you assume that Robert Bacon is the gentleman on the right of this picture. Anyway, he was from Long Island, New York, and he got an earful from his constituents when a VA hospital built in his district was awarded to a contractor who employed primarily a low-paid African-American workforce out of Alabama. The folks there did not appreciate that. They did not appreciate that the jobs didn't go to locals, and they did not appreciate what that workforce looked like, and also the fact that they weren't getting paid the prevailing wages. He tried for several years to pass a prevailing wage law, and then eventually he got James Davis, a senator from Pennsylvania and a former Secretary of Labor, to sponsor the Davis-Bacon Act with him, and it passed. So today we're going to talk a little bit about what the statute requires, but more importantly, we're going to spend a good chunk of time talking about the FAR Federal Acquisition Regulation clauses and some of the DOL regulations that implement the Davis-Bacon Act. And after that, we're going to spend the bulk of the time talking about, my view, best practices to achieve compliance with the Act itself as well as the regulations implementing it. So here is the basics of the Davis-Bacon Act. And it's a very, very simple statute when you really look at what it does. The statute itself only requires a couple of things. It says it applies to contracts for construction over $2,000 of public works and public buildings. I'll come back to that in a minute. And then it requires three things to happen. It requires that workers that work on jobs like that be paid at least weekly according to a wage determination established by the Department of Labor for the project. Secondly, it requires that you not deduct anything from those wages except for deductions that are permitted by law, things like taxes, things like that. And then the final thing it requires is that you post the wage scale prominently someplace at the work site so workers can see it. And that's all the Davis-Bacon Act requires. Now I want to go back and talk a little bit about the application of the Act because that can become interesting. But as a practical matter, you will know if your project is subject to the Davis-Bacon Act primarily because you should see contract clauses and a wage determination included in your contract that says, this is subject to the Davis-Bacon Act. Here's the wage determination that you have to pay workers according to. But before I get to that, let's look at exactly how the application language is worded in the Act, and then I'm going to talk about a recent case interpreting that language. So here's how the Act works, and this is a direct quote from it. The advertised specification for every contract in excess of $2,000 to which the federal government of the District of Columbia is a party for construction, alteration, or repair, including painting or decorating, of public buildings and public works of the government or the District of Columbia that are located in the state or district and which involve the employment of mechanics or laborers shall contain a provision stating the minimum wages to be paid to laborers and mechanics. So the requirement is that the government put a clause in requiring the payment of the minimum wages. It does not affirmatively require the contractor to do anything other than to comply with those clauses. So that's how you know it applies, because the government should have put it in. Now, I want to talk briefly about the City Center DC project, and I think we put a link to that in the Resources tab. That was a situation where the Department of Labor, and I bring this case up to drive home the point that the Department of Labor is looking for things to do and looking for situations where it can enforce the Davis-Bacon Act and other labor laws. That's why they're called the Department of Labor. Anyway, the City Center DC project involved a private development on the former site of the DC Civic Center. And the District of Columbia government awarded a 99-year ground lease to a developer to build a private development, included retail and office buildings and a hotel, on the site of the former Civic Center. A carpenters union went to the DOL and said, hey, shouldn't this be subject to the Davis-Bacon Act? And eventually the Department of Labor agreed. Now the District of Columbia government sued, and eventually the DC Circuit ruled that the Department of Labor got it wrong. It said that the Davis-Bacon Act didn't apply to that project because the ground lease and the development agreement associated with that project were not contracts for construction. Secondly, they said, look, the DC City Center project is not a public work or public building of the DC government because the DC government isn't going to own or operate those buildings. It didn't pay for those buildings. And the argument that they're inuring to the public benefit because there's tax revenue and maybe jobs associated with the construction those were not sufficient to convert what otherwise looks like a private development into a covered Davis-Bacon Act job. But I bring that case to light just to sort of demonstrate how aggressive the Department of Labor can be. All right, so let's start talking about the contract clauses that are going to apply in situations where you are on a covered project. And there are about 8 of them, and we're going to go through them all, and then we'll turn our attention to sort of compliance issues associated with them. First one is the Contract Work Hours and Safety Standards Act. That is the requirement that you pay time and a half for overtime. Overtime is defined as hours over 40 work during a work week. Now, there's an issue that can arise here that I want to alert you to. Your work week, and again, you have to be paid weekly on Davis-Bacon Act jobs, the work week can be whatever you want it to be. And your subcontractor's work week can be whatever they want it to be. It does not, the two don't necessarily have to align. You can have your work week start on Monday, the sub can have his start on Wednesday. However, this is critical, don't change your work week in the middle of the job. If you do, the Department of Labor is going to become convinced that you're trying to gerrymander it so that you avoid paying overtime during a week. So once you establish your work week or your sub establishes what its work week is going to be, they have to stick to it during the course of the project. Second clause I want to talk about is the Apprenticeship and Trainees Clause. The Department of Labor has an Office of Apprenticeship, Trainee, Employer, and Labor Services, and they approve apprenticeship and trainee programs for contractors that want to have them. And they're great, and if you have one and it's approved by the DOL, you only have to pay those apprenticeships and trainees according to what the agreement says. But the DOL is going to look at a couple of things when you have such a program. It's going to specify a ratio of apprenticeships, apprenticeship to journeyman, and that ratio has to be faithfully followed through. To the extent that apprentices are used above the ratio or outside the program, you have to pay them the full wage scale. Withholding of contract funds. This is the clause that says the government can withhold funds from any of your government contracts that they consider necessary to take care of Davis-Bacon Act related act coverage problems. So if they see that you're not in compliance on one contract, they're going to take the money necessary to cover payment of prevailing wages from workers on your other government contracts. The Copeland Anti-Kickback Act, that makes it illegal for an employer to charge its workers for the privilege of working on a Davis-Bacon Act project. And then finally, the compliance with Davis-Bacon Act and related regulations clause. That clause, all that requires is that all DOL rulings and interpretations of Davis-Bacon and related acts found in 29 CFR Parts 1 through 5 are incorporated by reference into your contract, and you are subject to them. So you need to know what's in there. And those are going to have things like how you compute overtime and what's working versus an authorized rest and all those sorts of things. The Payroll and Basic Records Clause. This one's pretty simple, although when we get into best practices, there's going to be a lot of additional records I'm going to recommend that you keep in order to demonstrate compliance. But all that is technically required is that you keep the Form WH-347, the wage and hour certified payroll record that DOL puts out. You keep the completed versions of those along with the statements of compliance that accompany them. And those show the name, the address, and all those list of 8 items that I identified there. And the requirement is that you keep those for 3 years. Now, I've been asked the question before, and I've actually researched this. What does 3 years mean? Does that mean 3 years from when the record was created or 3 years from when the project's done? The answer to that is there is no answer. So my recommendation is that you keep it from 3 years from contract completion. So if you have a construction project that drags on for 5 years, you need to keep those records generated in the first year 3 years after contract completion. At least that's what I would recommend as a best practice. It's not that much additional burden to keep the records around, and it avoids a potential problem. Disputes concerning labor standards. This says that you have to use the DOL's rules for resolving disputes about labor standards. Well, what is the dispute regarding a labor standard? Sometimes you'll have issues where a contractor believes there should be additional classifications of workers established under a wage determination, maybe a laborer standard or a journeyman standard for a different trade that's not listed on the wage determination. There is a process in the Department of Labor's rules for bringing that to DOL's attention and getting a DOL determination that may result in a revision of your wage determination. The second clause that we're going to talk about here, certificate of eligibility, that requires that the contractor certify that neither it nor any person who has an interest in the contractor has been debarred by the Department of Labor. And we're going to talk a little bit more about debarment in a second, because the Department of Labor has independent authority to debar contractors that don't comply with labor laws. In fact, let's talk about them right now. And this is the first of 2 slides that I have that are designed to scare the bejeebus out of you, so you pay attention to my best practices. Let's talk about this one first. Contract termination / debarment. So a breach of a Davis-Bacon related act can result in termination for default of your government contract. And as you know, terminations for default foul you because they get recorded in your past performance on CPARs and will go a long way towards preventing you from getting future government contracts. And that's not even considering the potential for debarment. If you breach Davis-Bacon related act clauses, the Department of Labor has authority to debar you, and which means you are not eligible to receive any federal government contracts or be a first-tier subcontractor. And if the violation is found to be aggravated or willful, in fact, the Department of Labor has no discretion but to debar you. The statement in the reg is that you shall be debarred for up to 3 years. But wait, it gets even worse. In addition to potentially having your contract terminated or being debarred, you also face possible False Claims Act problems. Now, I have a little bit of good, and I'll get to this in a second, but when you look at the Davis-Bacon Act forms, the certificates of compliance, they are tailor-made for False Claims Act cases because they require you to certify that all the information is correct and proper and that you have authority and all those things. And if you get that wrong, and they can show it, it is tailor-made. It's a crystal clear violation of the False Claims Act. And as many of you may know, you have your key TAM relators out there, the plaintiffs bar, that are looking for you to slip up because they can share in recoveries under the False Claims Act for claims that they bring. Now, there's a little bit of good news I want to share with you on the False Claims Act front, and that is one of my new favorite cases, Circle C Construction, called Wall versus Circle C. Now, that involved a contract between Circle C and the Army to build 42 warehouses at Fort Campbell in Kentucky. And what happened was Circle C failed to include Davis-Bacon Act clauses in its electrical subcontract with a company called FaceTech that was going to do all the electrical work on these projects. And in turn, FaceTech did not pay its laborers, its electricians used on the project in accordance with the Davis-Bacon Act. So there was a key tam lawsuit, and it was found that Circle C had violated the Davis-Bacon Act by not slowing down the requirement and not ensuring that the subs employees were properly paid. And the interesting thing is the damages in that case. The plaintiff had taken a deposition of the government's contracting officer in that case, and the government's contracting officer said, had I known that Circle C had not slowed down the clauses and that the electrical sub was not paying its workers in accordance with the Davis-Bacon Act, I never would have approved payments for any of the electrical scope of work on the project. Based on that, the district court held that the damages were the value of the entire electrical scope of work on the project, which happened to be $750,000. Now, that got appealed to the Sixth Circuit Court of Appeals, and it reversed. It found that the damages were properly measured as the difference between, or at least the single damage figure, because as you know, under the False Claims Act, you're liable for treble damages, but it found that the single damage figure was the difference between the wages that Phase Tech paid its employees and the Davis-Bacon Act wages, which turned out to be about $9,900. So that's a little bit of good news. But the good news ends there, because I want to talk to you about another case. And it's another case out of Ohio. And if you look at your resource tab, you're going to see that there's a blog article that we prepared about a criminal indictment in Ohio relating to Davis-Bacon Act violations. The case is called United States versus Marcus Butler. And Mr. Butler owned an electrical subcontractor that worked on various Department of Housing and Urban Development projects. And he was indicted and faces jail time for knowingly and willingly submitting false certified payrolls. That's all the indictment said. And I went back and I looked at the docket sheet on the case was filed, I think, a little over a year and a half ago. I checked the docket sheet yesterday, and this case still has not gone to trial yet, but he's not pled out. He's looking at potential jail time. And this is consistent, and it goes a little bit beyond the scope of what I have time to talk about here today, but this is consistent with the Department of Justice's approach under the Yates memo. And that is, they're going after individuals, not just companies. They want to hold individuals accountable for corporate wrongdoing. And the way you hold people accountable is you threaten them with jail time. And that's what Mr. Butler may be looking at for not getting his certified payrolls correct on his government contract. So hopefully I got your attention. If that didn't get your attention, let's talk about the last clause I'm going to talk about before we get to best practices, and that is the subcontracts clause. And what that clause says, it says, you prime contractor shall flow down all these Davis-Bacon Act related clauses, and I'll show you, I have them all listed here, into all your subcontracts, and that you shall get a signed statement of acknowledgement, it's called a Standard Form 1413, from each and every subcontractor at any tier. And then the last thing that clause says, and this is something that's repeated throughout the Department of Labor's regulations, the prime contractor shall be responsible for compliance by any subcontractor or lower tier subcontractor. Just slowing down the clauses in and of itself is not enough. I can't emphasize that enough. Just slowing down the clauses and saying, I flowed it down to the sub was obligated in the same way I was, is not enough. If a sub gets it wrong or a lower tier sub does not pay, and then they go bankrupt or go away and you can't find them, at a minimum, the Department of Labor is going to make you pay them again. You get the privilege of paying twice in some cases for the same work. That's the way the system is designed. So that makes it incumbent upon the prime contractor to do more than merely flow down the clauses. And you can see here, here's the list of the clauses that show up in that Standard Form 1413 statement of acknowledgement. And those are the same clauses that we just spent time talking about. Okay. So let's talk about, in my view, and we have a little bit more than half the time left to talk about how you go about making sure you comply with the Davis-Bacon Act and its attendant clauses. It's critical, in my view, that you have a layered system of compliance. Again, merely flowing down the clauses to the sub and making sure you get certified payrolls from them is not going to do it. It's not enough, and it will not protect you adequately from the Department of Labor or the Justice Department should a problem arise. So the two key individuals, if you're a prime contractor in your organization responsible for Davis-Bacon Act compliance, you got to have two people, not just one, but two people that are really invested and on the hook to ensure compliance. Now, everybody in your organization should be concerned about it, but there's really two people that are where the rubber meets the road on this issue. And the first person is your job site superintendent, because he or she is the person that knows who's there working every day. And then the second person is you need to have somebody that's working in that job site trailer who has, if it's not their only responsibility, who has a clear responsibility for making sure certified payrolls are submitted and that they are accurate and correct and current. Now, that person, in my view, should not be a project manager who has responsibilities for overall making sure the project gets built properly, or a project engineer, or just a project admin to do this as other matters as assigned. If you're dealing with a project of any sort of size and or involves a lot of different trades, you may need one, if not more than one person, whose sole responsibility is to make sure all the paperwork associated with Davis-Bacon Act compliance is being submitted and that it's accurate. And I'll talk a little bit about what I think those responsibilities should be. But let's look at a high level what some best practices are. Obviously, you're contractually required to flow down the clauses. You cannot subcontract away Davis-Bacon Act compliance by introducing multiple tiers. It applies at all tiers. So anybody who steps foot on that job, and it's, by the way, it's beyond the scope of my talk today to talk about secondary sites of work and things like that. There are clauses that deal with that. But for our purposes today, anybody who steps foot on that construction site that's going to install something or do physical work on that project site, you need to know that they're there. We need to know what classification they fall into. We need to know the number of hours they work. Secondly, you have to have some sort of record in addition to the certified payroll to establish who is at your job and how many hours they work. And I'll get to that in a second, but I believe you need that. Now, there's nothing in the regs that say you have to have this, but it's my view of, as a best practice, it is extremely important to have this record so that when you receive a certified payroll, you have something to check it against. Regularly communicate, before I get to that, obviously you want to follow your obligations to retain your certified payrolls, your statements of compliance, those things that are required. At the end, I'm going to talk about some additional records that you should be retaining so you can demonstrate that you're in compliance. Regularly communicate with your subcontractors about compliance. Make sure that they are aware of their obligation, not only to comply for themselves, but also to make sure that any lower tier subcontractors that they may get involved are also in compliance, and that they sign a statement of acknowledgement. That standard form 1413. They've got to sign that. You should have that for every subcontractor at every tier, that they acknowledge that all those FAR-related clauses that implement the Davis-Bacon Act are included. Next best practice, do on-site interviews of subcontractor employees. And it's probably that certified payroll clerk that should do it. Or if you want to have somebody in your compliance or audit function come out and do it, you need to do this. Because the Department of Labor is going to come and do it. And it is very helpful if they find a problem that you can go back and point to your records and say, you know, we've been talking to the subs employees as well, and here's what we're hearing. Retain all the records that demonstrate compliance. And I'm going to go through the things beyond just the certified payrolls and statements of compliance that you should be retaining. And then the final thing, and I bold it for a reason, the best way to make sure people will comply is don't pay them. If your subcontract, your standard, if you're a prime and your subcontract does not specifically say, I'm going to withhold payment from you if you're not in compliance with the Davis-Bacon Act, you need to revise it and make it say that. Or make it crystal clear that that's a consequence of them not having their certified payroll submitted properly and in a timely manner, for not making sure that their tiered subcontractors are doing the same. You've got to do that. That is your leverage. Once you pay them, it becomes more and more difficult to insist on compliance. And again, at the end of the day, the Department of Labor holds the prime contractor responsible for compliance. So this is your, power of the purse is your leverage over the subcontractors to make them see how important it is to comply. You've got to have some sort of record in addition to just what comes back on a certified payroll that shows who was on the job site and for how long. It's insufficient to merely rely on the certified payroll alone to establish that. You should have some other contemporaneous record to demonstrate that you can use to check back against that certified payroll for compliance. What form you should use, you can put that on your daily report. You can generate a different record called a daily force report or a manpower report. You can put it on your CQC report, but somebody on a daily basis, and this is something you should make the sub do, and develop a form that you give to your subs on Davis-Bacon Act jobs that say, look, on a daily basis, list who worked, provide the ID of the individual, tell me what class they are they a laborer, are they a mechanic, are they an electrician, and tell me how many hours they worked every day. And make them submit that record every day that they're on the job. That is your first line of defense to ensure compliance. Make the sub submit a record showing who was there and how many hours they worked every single day, including if they don't work or had nobody on the job that day, make them submit a record saying no work today and sign it and send it to you. Because you would be surprised if they get behind on their certified payrolls, all of a sudden they're going to say people worked on days where you really didn't see people, or there's going to be a discrepancy between the number of people there that show up on this daily record versus show up on the certified payroll. You need to have some sort of way to verify who's there, and you should make the subcontractor submit that form to you. So what are you going to do with that form? Well, the superintendent should get that form, and they should timestamp it, and they should look at it against their own records of who they think was on the job. And again, the superintendent is the one that's walking the job sites, communicating with the trades, monitoring and controlling their work on a daily basis. So that superintendent, as part of their job responsibility on a Davis-Bacon Act job, they need to know who's there. They need to be receiving from the subcontractors, preferably by first thing in the morning the next business day, this daily record showing who's there. And then the superintendent should compare that against their notes of what work took place and how many people they saw on the job that day. And if there's a discrepancy, it needs to get resolved hopefully right there and then. But once that record is received by the superintendent, they then should forward it up to the certified payroll clerk, whoever this individual is that's going to have primary Davis-Bacon Act compliance responsibilities inside your job site trailer. They are going to review that daily record to make sure that everybody's listed, that there's some sort of identification number. Usually it's going to be the last four of their social, that the classes of that the individuals worked in are listed, and that they match up to something that's on the wage determination, and that the hours make sense. And we'll talk about comparing those to the certified payrolls in a little bit. The second thing you got to make sure you get, and this is obviously the thing that's required by statute that you get, is the wage and hour form 347. And this is what it looks like. I'm sure many of you have seen it before. And it has, space to put your name and the ID number and the wage class, straight time and overtime, the rate of pay, and all those sorts of things. Every sub that's on the job, regardless of tier, needs to be submitting these on a weekly basis within 7 days of their payday. There's the second part of that form, which is the statement of compliance. Now, at the very bottom right of the statement of compliance, it has that 18 U.S.C. statement. And for those of you that don't know, 18 U.S.C. is a criminal statute. And that says it's a crime to say anything false in this statement of compliance. And the statement of compliance says, I paid everybody according to these wage determinations. And you also have to spell out exemptions, withholdings that you're making that aren't authorized by law. You've got to explain them on your statement of compliance. Now, a best practice with respect to the statements of compliance. The individual for the subcontractor that signs this document, my recommendation is that you get some sort of affidavit from them attesting to the fact that they have authority to sign that document on behalf of the subcontractor. And that's something that your certified payroll clerk can check to make sure that they have on file an affidavit for everyone that signs one of these certificates of compliance. And that's a record that you're going to want to keep in addition to the statement of compliance and the 347 form itself. Okay, so what do you do with these forms? So you're going to get these forms in, and again, you need to receive them within 7 days of that sub's payday. Now remember, the subcontractor has to pay its employees on the Davis-Bacon job at least once per week. But what their work week is up to them. Please don't let them change their work week. If they are, it's going to lead to the implication that they are monkeying with their work week in order to avoid paying time and a half. Your certified payroll clerk should receive those certified payrolls and statements of compliance, and I'm going to talk through the process of what that clerk needs to be doing. They just shouldn't put a copy of it and assume everything's okay. Again, because you're on the hook for noncompliance at lower, with subcontractors and lower tier subcontractors, it's critical that somebody do more than just receive the form and make a copy of it. They need to check that the dates are correct. They need to make sure that all the certified payrolls are sequentially numbered, that the certified payroll dates match the dates on the certificates of compliance. I've seen situations where a sub will submit the same certificate of compliance and just sort of photocopy it and put it on the back of their certified payroll. That's not sufficient. They have to have uniquely executed statement of compliance with each and every certified payroll. And so the clerk is going to make sure those two things match up. And then here's the critical steps. They're going to make sure that the sub's name matches the name on the 1413 form, that statement of acknowledgement that we talked about, that same sub matches the daily record, the manpower report or daily report or force report, whatever you choose to call it, that name matches for that sub, and that it matches the name on the statement of compliance. Why is it important? Because this is where you run into situations where your sub will have these lower tier subs that you never knew about. And all of a sudden you get a certified payroll for somebody that you hadn't heard of. Well, that's going to trigger you knowing that you need to go back to your sub and say, look, you got to get a 1413 for this guy. And oh, by the way, I'm not going to pay you until I have all the documentation demonstrating compliance for both yourself and all your subs, Mr. Subcontractor. Make sure that the individual, your clerk is going to make sure that the individual that signed that statement of compliance, that you have an affidavit on record for that individual saying that they have authority to sign. And then they have to match up. They got to go through the process, and it's very tedious, but someone's got to do it. They've got to match up. Compare the daily record to the certified payroll. Are the same people listed? Is everyone listed on one, listed on the other? Do the hours match up? Are the wages being properly paid? Is it according to the scale? Are the classifications the same between the two records? All the things like that. And again, I can't emphasize this enough. If somebody, one of your subcontractors, does not have complete and accurate records, consider not paying them and make sure that your subcontract indicates that if they don't have their certified payroll records and Davis-Bacon Act compliance records properly submitted to you, they don't get paid. Again, the statement of compliance, it has to show all the payments that were made. It has to show all the hours. They have to match up the hours that are from the certified payroll. The full names and last four of the Social Security number for each person that's paid. You've got to make sure that the rate of pay and the fringe benefit amounts meet or exceed the amount indicated on the DOL's wage determination. You've got to go through and do those overtime calculations. Again, it's not calculated on a daily basis. It's those hours over 40 during a work week for which employees are entitled to time and a half. And that all deductions that are not authorized by statute, like deductions for taxes, are noted. So if you have a 401k or a health care program that they're paying into, that a deduction is taken out of their pay for that shows up in the statement of compliance. And again, your certified payroll clerk is going to compare the certified payrolls to whatever this daily record is. And once they reconcile the two, my suggestion is, another best practice here is that you keep a log of each and every certified payroll and statement of compliance that you receive. Have them keep a log, keep it in Excel or some other program to show that when you received it, and that you're logging it in as received under the sequential number and that is listed on that certified payroll. If there's discrepancies, if the clerk is finding problems, there's a disconnect between the daily record and the certified payroll, or the statement of compliance is not right, that log should be noted with what that discrepancy is. Any correspondence that you have with the subcontractor thereafter, where you tell them, hey, I got your certified payroll, you have 3 people listed on your daily report for May 2nd that don't show up on your certified payroll, this seems to be inadequate to me. You keep a record that you sent that, and you note that in this log. So that certified payroll clerk is going to have the primary responsibility for communicating with the subcontractors regarding any discrepancies. Document the issue in the log. Document the dates that you had communications with the subcontractor about it. If it's just a phone call, record. Had phone call with sub this day. Preferably, the clerk is submitting emails to the sub, and therefore there's a record that can be kept that should be put with the project records so you can demonstrate that you made attempts to comply. If the daily report is wrong, whatever this daily record is, if there's a discrepancy between the certified payroll report and whatever this daily record of who was on the job, if they don't align, and the problem seems to be with the daily record, you need to get a new daily record. So keep the old one, get the new one, and mark it revised, and keep both of them. Work with the superintendent to make sure when you get this revised daily record from the sub that it comports with his or her records of what activities took place on the job site that day. This is what that looks like. Line through the one, get the revised one, which has the additional individuals listed or not listed as the case may be, or corrects the hours. Let's assume that there's a discrepancy, and the discrepancy shows that the certified payroll is wrong, and that some people didn't get paid that should have gotten paid. There's people that show up on the daily record that don't show up in the certified payroll. You point that out. You should request and receive a revised certified payroll from that sub along with a statement of compliance. And assuming it matches up with the daily record, you mark that revised, keep both. But in addition to that, you want to have proof that they made payment. So that should be a copy of a check stub, a direct deposit receipt, a copy of a check, something that shows that they paid that employee. Then line through the old one and mark the new one revised and keep both and include them in your log. Here's what that looks like. All right, let's get into a couple of little problem areas here. The first one is the business owner who works on the job. And the rule is if you're a bona fide business owner or executive, you don't have to pay yourself Davis-Bacon Act wages. You should receive, if anybody falls into this category, you need to receive for them some sort of statement that says very clearly that they meet two standards, and the standard is set forth in 29 CFR 54101. And the two standards are as follows. They have to have a 20% equity interest in the company, and they have to be actively engaged in its management. It is not sufficient to say that Timmy and Billy, who are laborers, are also executive vice presidents. That won't do it. Unless Timmy and Billy, the laborers, also own 20% of the company each and are actively involved in its management. If Timmy and Billy, the laborers, meet those standards, then yes, they don't have to be paid Davis-Bacon Act wages. But make sure that Timmy and Billy both sign a statement that say and attest to you that they have this 20% interest and they are actively engaged in the management of the company. It's going to take a second to pop up here for some reason. But next we are going to talk about, push to audience. Let's see if this works. There we go. 1099 workers, independent contractors. This is an area where folks run into problems because Mr. drywall sub or Mr. Electrical sub or Mr. Curb and Gutter sub says, I don't have employees. All my employees are independent contractors. Haven't you heard about the sharing economy in Uber? They're independent contractors. They're not my employees. According to the Department of Labor, independent contractors are considered employees of a subcontractor for which they work. So anybody who says that they're an independent contractor, whoever they work for, that's considered to be their employer. And that employer has responsibility to make sure that they are paid Davis-Bacon Act wages for the hours that they work on your project site. If you run into a situation where somebody is claiming to have independent contractors, say that's great, list them on your certified payroll, list them in your statements of compliance, and list them in your daily reports. I want to see them. I need to know who they are. I need to know how many hours they work, and I need to know what classifications they work, and I need assurances that you're paying them Davis-Bacon Act wages, because you cannot contract around Davis-Bacon Act compliance. Be extra diligent. Can't emphasize this enough. Anybody who's telling you they're coming forward with they only have independent contractors, they don't have employees, they're doing this because they think they have a scheme to not comply, or at least that would be my suspicion. So your superintendent really needs to be on his toes to make sure that those daily records that they get from that subcontractor match up and show all those independent contractors out there. You can't say, oh, those guys aren't my employees, they're independent contractors. Wrong. If they're taking direction from that sub, they need to be listed on that sub's daily record as well as on their certified payrolls and statements of compliance. If somebody is insisting that they don't have employees, that they only use independent contractors, again, my experience has been they're not doing it for a proper reason. Consider not using them. And I know your project executive is going to be all upset with you when you tell them that, because they bought out that subcontractor so cheap and they're so happy because they're going to make more money for the company on the job. But they're in the long term, they're buying into a potential problem. Piecework. This is a favorite. Piecework is fine. I know certain trades, the sort of standard practice in the industry is to use piecework with painting and drywall and things like that. And that's okay, except you have to make sure that the piecework workers are being paid at least the prevailing wage for the hours that they work. Let me read for you the quote from the reg on this, from 29 CFR 778-111. When an employee is employed on a piece rate basis, his regular hourly rate of pay is computed by adding together his total earnings for the work week from piece rates and all other sources such as production bonuses, and any subs paid for waiting time or other hours, except statutory exclusions. This sum is then divided by the number of hours worked in the week for which such compensation was paid to yield the piece worker's regular rate for that week. So you look at all the hours they worked, and you look at how much they got paid, divide the two together, and that's going to establish their regular rate of pay. And it better be at or above what the wage determination says for that classification of work. So piecework's fine, but it doesn't really quite work the way it typically would on a Davis-Bacon Act job, because they have to be paid the prevailing wage for every hour that they work on the job. Okay, we talked about this earlier. This is a requirement that comes directly out of the statute itself. You've got to post two things prominently on your website. First thing you have to post is that poster. And you can download it from the DOL's website, and you need to put that poster up. And this tells people that, hey, you're on a Davis-Bacon Act job. Second thing you got to post is you got to post the wage determination itself. And that's a little document. You know what that looks like. It's going to be that report that you get from DOL that runs through all the classifications of workers and establishes hourly rates for each and every class, and it establishes the fringes and vacation pay and all those wonderful things that folks that work on a scale job are entitled to. They have, both of these items need to be posted someplace prominent. I think a job site trailer is prominent enough. And do yourself a favor. Take a picture of these items posted in your job site trailer and keep a record of that. All right. My last two slides here are going to deal with the kinds of records that you need to be keeping. So the first thing that you need to be keeping are the things that you're obligated by statute to keep. And that is basically only two things. It's going to be your 347 certified payroll submitted for yourself and for each and every one of your subcontractors. And again, that wage and hour form 347 has all these 8 items of information: the name and the address and the hours worked and the class and the deductions and all that. That's all on that form, and it needs to be filled out completely, and the hours worked. So that record itself is one of the things that you have to keep. You have to keep the statement of compliance. And again, you have to keep those items for 3 years. My recommendation, because I've not seen authority to the contrary, is that you keep them from 3 years from when you complete construction on the project, not from 3 years from when that record was generated. So those are the things you absolutely, by law, you have to have. Now here are the things that you should also have so you can avoid problems with the Department of Labor and hopefully avoid problems, if it gets really bad, with your friends at the Department of Justice and the local Assistant United States Attorney. Remember those statements of acknowledgement? Those forms that say, hey, I'm the subcontractor and I acknowledge that all the Davis-Bacon Act clauses are included in my contract. You need to have one of those for each and every sub at any tier. That's a record I definitely want to keep. Remember we talked about getting an affidavit for each and every individual that signs a statement of compliance attesting to the fact that they have authority to sign that statement of compliance on behalf of the sub. Those affidavits, that's something that I'm keeping. Remember we talked about a certified payroll log where your certified payroll clerk is logging in each and every certified payroll and statement of compliance they receive, as well as documenting communications with subcontractors where discrepancies arise. Keep that log. We talked about a best practice being interviewing subcontractor and particularly lower tier subcontractor employees to make sure that they're aware that it's a Davis-Bacon Act job and that they are actually being paid on a weekly basis in accordance with the scale for the job. Do those interviews, and most importantly, document that you do them. Because again, the Department of Labor is going to do them itself, and you go a long way towards making them comfortable with your compliance if you can show that you've done that yourself. And then, if applicable, if you're running into problems with subs, make sure that you keep all those correspondence that you had with the subs regarding their noncompliance. You've got to revise certified payroll from them, that you sent them a notice that their daily record and their certified payroll and statement of compliances didn't match up. To the extent that the subs or your own organization satisfies fringe benefit requirements by providing health care or 401k contributions, you have documentation demonstrating, showing what the program is, So you can demonstrate compliance that the fringe benefit rates are being properly paid to the extent that the employees are not choosing to receive cash in lieu of fringe benefits. Finally, to the extent that there's an apprenticeship or trainee program, make sure that you have documentation that that program has been approved by DOL's OTEL's office, the apprenticeship office that we talked about earlier, or a state program that the Department of Labor recognizes as well. And these are the records that I recommend that you keep. And I think with that, I've reached the end. Now, I'm gonna click over. Oh boy, I'm gonna see if I can address a few of your questions. It looks like we have quite a few. So let's see if I can do a couple of them in real time. And I'm just going to start from the top here. And I have a question from Mr. Spickard from Jacobs Engineering. Can a subcontractor have an employee working on a different task at a different wage classification? And can that employee be paid at those different rates? An example, an employee working as a general laborer and as a truck driver. Yes. The safest thing to do is have them paid at the higher rate, but it is possible where you run into situations where Bob the driver is a truck driver today, and then for a portion of that time he becomes a laborer when he's unloading the truck. This is a situation that can be rife with problems because the subcontractor and your superintendent should be noting how many hours they're working on each task, and I guarantee you they're not going to get that right. Let me do just one more question, and then I'm going to conclude. And I have a question from Jan Millington from the city of Springfield. What is the liability of the owner for the missteps of a contractor on their documentation, if any? Good news, Mr. or Miss Owner, you're okay. However, that would protect you from the Department of Labor. It may or may not protect you from an ambitious plaintiff's attorney pursuing you in a False Claims Act case if it finds that you as the owner take a lax attitude towards Davis-Bacon Act compliance. If you are not insisting that your prime contractor submit certified payrolls to you, and or you don't note open and obvious mistakes with certified payrolls that you're receiving from your prime contractor, if I'm a creative plaintiff's lawyer, I'm going to bring you in the False Claims Act case as an additional potential deep pocket to turn to. So I've never seen that situation arise before. It's certainly not built into the regulations of the statute itself, but there is your reason, in addition to just being the right thing to do, there's your motivation for making sure that your prime contractors are diligent in compliance with the Davis-Bacon Act. We're a little bit over an hour here, so I'm going to wrap it up. Thank you for joining us for our program today. We hope that the information provided was helpful for you and your organization. If you've not done so already, please click the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Missouri, and Tennessee CLE credit. Nebraska and Texas are pending. If you want CLE credit for your state, let us know. We'll try to help. A recording of the webcast will be available tomorrow for watching and sharing. Once again, a link to the recording will be emailed to you along with the certificate of attendance. This concludes our webinar. Thank you.